Hello everyone, welcome to another edition of Tips to Top the Unofficial Bar. Today I have with me one of the famous and very known President Counsel, Mr. Kalinga Indatissa with us to share his experience and advice to the young lawyers and law students. Thank you for your time, sir, for giving us for this interview. We would like to first ask you about your beginning of the professional career. Whether you came from the law college or from the faculty, and have you had an intention to become a lawyer when you are a young student?
Yes. My first intention of taking to the legal profession when I was about 7 years old. There was a book that I read of Mr. W. D. Silva called Hinganakolla, the beggar boy. And in that particular book there is a character called Sir Henry, who plays the role of a Supreme Court judge. At one point in the book, he has to sentence his own illegitimate son to jail. The mental and the psychological trauma which he went through is one of the reasons which persuaded me to pursue a career in law. That is the commencing point. And thereafter, I joined the law college relatively at a young age of 17 years. And after having joined, I saw that there were many areas of the law which could be explored by a law student or a young lawyer, and the law in certain stages and in certain areas had not settled down by that time. I joined the law college in 1982. Thereafter, I passed out in 1986. Having passed out, I was basically 22 years at the time I was called to the bar. And I did my pupillage or apprenticeship as we call it now in the chambers of Mr. Attornery-at-Law President's Counsel and also Mr. Tiwanka Vikramsinghe, President's Counsel. I also used to work with Mr. D.S. Vijayasinghe, President's Counsel, in the appellate courts. The experience that I gathered prompted me to pursue a career in the Attorney General's Department, because except for Mr. Perera, all the other seniors whom I worked with were members of the Attorney General's Department in one point of their life. So thereafter in 1987, on the 1st of January, I joined the Attorney General's Department as a very young state counsel. I was there for a period of 5 years, working in the criminal section and more in the civil section. And that exposure gave me a lot of encouragement and a lot of tips to develop a career in the legal profession. I must say that one of the things that I learned from the Attorney General's Department, which I respect until my dying day, is the mechanism that they have. During that period, we were supervised by giants like the late Mr. Shiva Paspati, former Attorney General, Mr. Kudatunga, former Solicitor General, Mr. Sunil De Silva, Mr. Kamal Suneth, Mr. Sarath Silva. All those people, they gave us a lot of freedom to be involved in our own line of thinking. I think it's very important for a lawyer to develop your own mind rather than just reading from a script or reading from a book or reading through a judgment. One of the things which I learned in the Attorney General's Department in my initial years at the bar was to go behind the basic foundation or the basic principles of law. Even today, when a person analyzes a point or makes an attempt to study a point, it is my thinking that a grasp of the basic principles of the law would play a very, very significant role. I can give you two examples. The late Mr. H.L. De Silva and Dr. Colvin Silva. Now the younger generation of today will not have the benefit of seeing either of them, because both of them are dead. But now if you take Dr. Colvin was a person who never carried many books to court. He would always take the Criminal Procedure Code or the Penal Code and take a section and take a word and then argue on that word, the real true meaning of the intention of the legislature, what the person who drafted the code would have intended it to be. So I have learned a lot through my tenure in the Attorney General's Department, which I value very much. So the beginning was not all that easy, because I remember I spent about 6 months in the Unofficial bar before joining the Attorney General's Department. And then thereafter in 1987, I had to adapt to a salary of 2,700 rupees, which was at that time, which was a basic salary. And that 2,700 rupees was well, good enough to make money, to make a living. So thereafter, one thing which I learned, even from my initial years at the bar, is not to go behind money. Money will come at a subsequent stage once you master the art of law. And that takes time. And the values which were put into us by our seniors. I have to mention here, Mr. Perera and Mr. Thimakam, both are dead and gone. But every day they used to spend time with us, talking to us about the history of the profession and how it should be. Now, one of the things which I learned, which I find very sadly lacking today, is the love for the history of the profession. This is not a profession which has been built overnight. It was not, Rome was never built in a night. Likewise, the legal profession was also not built in a night. There are certain things that you can learn from the seniors by watching them. Now, we have a few members of the bar who still got educated during the colonial period and the period turbulent periods that the bar went through, who still respect the traditions and the values of the profession. I think it's very important for us to do that. So I would in a nutshell say, the beginning was not that easy because I don't come from a legal background. My parents both were public servants and I never came from a legal background. It was hard, but one other thing I have to mention is we had excellent lecturers at the law college.
In the college.
Yes. I am a law college product and I am proud of it. I am proud of my lecturers. I respect them. There are very few people who are living today. Mr. W.K. Premaratna, who was my lecturer in criminal procedure, and we used to attend lectures and learn and benefit through the experience and the exposure that these gentlemen had in their respective careers. So I would say I come from an unlegal background, but I was always confident and I was dedicated to what I wanted to do, and that is why I sit in this place in the profession now.
So when you start the profession in the, you said initially 6 months with the unofficial bar, then went to the Attorney General's department. Have you had an intention that you will pursue civil law, criminal law, or did you pick that you will do criminal law? Because now, as of today, you have mastered both civil and criminal, and you are one of the pioneers to introduce the money laundering law to Sri Lanka, and you have written a number of books. I believe more than 25 books.
40 books.
40 books, I'm sorry, 40 books of criminal side, civil side, and covering vast areas. Now, this is, I consider as an exceptional talent because we find often lawyers either concentrate on civil law or either concentrate on criminal law or either concentrate on instructing law. Now, have you had the idea of you will do both civil and criminal at the beginning? How that you came to today's position where you mastered both civil and criminal?
No, it always what interested me most, even from my young days, was the field of criminal law. There was a reason because lot of people have this thinking that any person can do criminal law. That is wrong. Every person can't do criminal law because to be a successful criminal lawyer, you have to be very sharp on your feet. You have to be extremely intelligent. And also, you should be able to pick up from the word of a witness, if it's a trial court, and then work on that word.
With few seconds.
Yeah, in a few seconds. You don't have time to plan.
Yeah.
But most importantly, all good criminal lawyers have read their brief from cover to cover. That is the most important thing. Now, what happened to me was, I wanted to do criminal law. And one of the earliest breaks that I had in my life was long time ago, in the 1980s, there was the first abduction and ransom case in Sri Lanka, Mathugama Saman Kumar case.
Was that the first case?
First case for abduction and ransom. And in that case, I had to make the bail application. And I remember I was making the bail application before Justice G.P.S. De Silva and Justice Justin Abeywadana, who was in the court, who were judges of the Court of Appeal at that time. At that time, the Court of Appeal is located where the divorce court is now.
Okay.
So when I made the application has been refused 3 months before when my senior, Mr. Perera, made it. So when they came for a second time for a second bail application, Mr. Perera told me, you are good on bail, you just go and make the application. I was retained, I made the application for a very small fee.
How long now at that time? How many years you were in the bar?
This is I am talking about 3 months in the bar.
Okay, right.
3 months in the profession. So then I drafted the application. We had no computers. I typed it myself. I had a old typewriter which was gifted to me by my father. On that I did the typing, filed it, and then I supported. And on the day of the inquiry, the court decided to grant bail. I still remember this. This is what is important for the young lawyers actually. Then, when the court decided to grant bail, Justice G.P.S. De Silva asked me, is your client here? I said no. Then he said, okay, can you please check with your client whether 25,000 rupees they could afford to keep as bail. Those were the judges of those days. Because bail is a very important matter which involves the freedom of an individual.
Yes.
And they treated that in that angle. So I used the word, I told the court, I will instruct my client to do so. Seated next to me, I was standing, was Dr. H.W. Jayawardena. I never known him. President Jayawardena brother, Queen's Counsel. I never worked with him. I had never been a juror to him. The moment then the case was postponed to 2 days for me to give time to get instructions from the client. The moment, you remember the words I used is, I said, I will instruct my client.
Yeah.
Then Dr. Jayawardena said, if you have finished your work, you wait until I finish mine, I need to talk to you. That was not a request, that was an order.
From a President Counsel to a very young lawyer.
So I waited till he finished his work. He walked up to me, he asked me for my name, then asked me where I studied. And thereafter he said, you have a long way to go in the profession, but you made a fundamental mistake when you made this application. You told the court, I will instruct my clients to do so. He says, lawyers don't instruct clients. Clients instruct you. The correct word that you ought to have used is, I will advise my client. From that day, believe me, I will never make that mistake. Now, I wanted to be a criminal lawyer. I joined the Attorney General's Department also with that intention. There were 4 of us who were taken into the department. Current additional Solicitor General Mr. Shavinda Fernando, Mr. Atula Patinayak, who is lecturing in Australia at the moment, Mr. T.W. Karunathan, who is also in Australia at the moment, and myself. When it came to everybody's dream when you join the AG's department is to get into the criminal side of it.
Passion is there.
That is the passion, where drama, court craft, court work, where I relate to people. The late Mr. Joe Perera, who was in charge of administration, he walked up to me and walked up to us and said, who is the youngest of all? Then I said, I was the youngest. Then he said, Justice Kudatungu, who was then Solicitor General, wants you on the civil side. My entire life crashed from that moment. Right? But believe me, when I joined the civil side, I started analyzing points and identifying arguments from a civil point of view. How to be analytical, how to develop a written submission. Which opportunity was not available as much as it was available to a civil side counsel in the criminal law, in the judicial department. So, then came another thing, because as you know, I have lectured at the Law College from 1987 to 2003, I did lecture. And during that period, I used to lecture in many subjects. Civil Procedure 1 and 2 was 2 subjects. So that exposure gave me an opportunity to understand the civil side of the law. But I would say, any day, to tell you honestly, I find civil law, normal civil law, unless it's a challenging argument or a point, very boring. But in criminal field, I find that criminal law is very extremely interesting and also it's thought-provoking. Now, having said that, I must always say that I don't generally appear in drug matters or defend in rape cases, child abuse or child molesty. and also where weapons and contract killings are involved. I just leave them aside. I don't say that those suspects should not be defended by counsel, but as a matter of policy, I don't have that. That is what I got to say in response to answer question.
Yeah. Sir, now with decades-long experience initially in the official bar, then in the unofficial bar, would you like to share with us some of the unforgettable memories you had in the court, from which you think the young lawyers and law students can learn something? I know there may be hundreds of things, but would you like to pick one or two and share? I remember in one lecture you told us about how Mr. Perera cross-examined a certain rape case where he contradicted. Yeah.
There are two things. There are two things that I want to, two stories that I can think of. And both these stories, at the end of the day, you will know it has a meaning. One day, I was asked to go and prosecute in Negombo when Justice Sri Lanka was the judge. The State Council, Permanent State Council has gone on leave, so I had to finish 2 weeks to fill his gap. I went at about 10:05. Justice Sri Lanka is one person who respected punctuality. He sits on the dot at 9:30. He would always, you can set your watch on that.
So the court starts 9:30? 9:30.
Right. So I did not know that. This is after vacation. So I had gone to Negombo at 10:05. He had come on the bench at 9:30 and put a minute. The time is 9:30, no state counsel to prosecute. I adjourned the court by 10 minutes.
10 minutes?
Yes. Right. Again 9:40, same minute. 9:50, same minute. Again 10 o'clock, same minute. So 4 times he had read on the bench and postponed because there was no state counsel to prosecute. Then I walked in.
So you didn't know that this thing happened?
No, I never knew that he used to sit at 9:30. But that was not an excuse.
Yeah.
When this happened, now today, the young counsel will always make that as an excuse. I did not know. What I am going to tell you is different. So when I walked into his chambers at 10:05, he didn't even offer a seat to me. He said, "Who are you?" I said, "I am the state counsel." "Who told you to come?" I said, "The Attorney General sent me." He took a call to the Attorney General, Mr. Shiva Pasupati, at that time, and said, "Mr. Attorney General, who is this clown that you have sent here?" And you better tell him that my court sits at 9:30 and not at 10:05. Then he came on the bench. I thought I am finished at the beginning itself. But every submission I made, he held with me on that day. He did not carry the problem that he had with me to the bench. That is why I always respected Justice Sri Lanka for giving me that lesson in life, not to be late and to be punctual in your professional dealings. That is number one. Number two, when you put the black coat on, most of us at the beginning, they have a tendency to think that we have learned the law. That is only the beginning of learning. What you learn at the law college, the law faculty, the Royal Institute, the APIT, or any other higher education institute, or the Open University is nothing compared to the learning that you commence at the bar once you become a lawyer. Now I was very young at that time. I had just been called to the bar, and there was a rape case in Amelipitia. Those days there was a non-summary rape case, and the whole weekend the brief was with me. Mr. Perera was senior counsel, I was junior to him. The whole weekend the brief was with me. And on Monday morning he picked me up from where I was staying to go to Amelipitia early morning. And in order to, it's natural, when you are young, you try to impress your senior. So what did I do? Over the weekend I studied the entire law relating to rape. I identified the case law and made a beautiful note. And I gave him as I got onto the vehicle.
Hard work, right?
Work. He took the brief and put it aside. And he never spoke to me about anything until we got close to Palmandula. At Palmandula he said, "Take the brief." And he said, "Read the notes, read the statements, read the evidence." So I went through. That was about 20 minutes.
So you were reading, he's listening while
he just listening. That was for about 20 minutes. Then we went to court. Case started, packed courthouse. the prosecutrix gave evidence there. The story was, the prosecutrix was 16 years old and a very beautiful girl. The accused was a young man of 18 years. He had a job in Mahavali System C. And every Thursday he comes home. Thursday, Friday, Saturday, Sunday he is at home. And he plays the role of a cashier in a boutique owned by his brother. So those 4 days he is there. The girl had come to buy some provisions. And according to the girl's story, he gave the provisions. And while giving the balance money, he held her by a hand, took her to an interior room and raped her. That was the story. So the prosecutrix came to do evidence. She gave evidence. She stuck to a police evidence, gave beautiful evidence. When the time came for cross-examination, the judge asked Mr. Perera, any questions? He said, no questions.
So no cross-examination?
So normally, in a rape case, you have to cross-examine the prosecutrix, the victim.
Yes.
That is what we have done.
Yes.
So I thought this man is catching up. His age is catching up. I think he's not doing his job properly. Then came the mother, because immediately after the incident, she had gone and complained to the mother, and mother went to the police station. Right? Came the mother. Perfect evidence. Timing was okay, consistency, spontaneity, everything was there. Then suddenly, any question, Mr. Perera in cross-examination? No questions. So I was flabbergasted. I knew that we are going to lose this case. Then came the police officer. Now, if you remember, her evidence was when he grabbed her by the hand while giving the bag of provisions and took her inside the room. Then came the police and the bag fell, provisions fell onto the ground. He struggled, the bag of provisions fell. Then, when the police officer came to do evidence, Mr. Perera asked him, I have a few questions. Have you made notes? Yes. Did you go to the scene? Yes. Did you find the bag of provisions? Yes. Where was the bag of provisions? On the table.
On the table?
On the table. Right?
Right.
Then he said, no questions. I don't think even the learned magistrate understood what he was coming to. Then the prosecution closed the case. Then Mr. Perera said, there is nothing for me to call for a defense here, no witness was needed, because Your Honour heard the girl said that she fought and the bag fell. Contrary to that, the bag was on the table. And even if she struggled, if the bag faced some resistance, there were some eggs in the bag. He got the contents of the bag from the police officer. Whether he had noted down the contents of the bag, what would have happened to the eggs? The eggs would have got crushed. The accused was discharged. He looked at me and said, what happened to your research? Now this is, the message is this. The message is, don't ever think that your senior is a fool or that he is catching up in age. Because the experience that any senior at the bar would have achieved over the years would surpass knowledge on the part of a young lawyer. A young lawyer, any lawyer, in my opinion, has to have the knowledge and the exposure and the experience all. Then only you develop a career, you are successful, that will be successful at the bar.
And so I think it's a very good example where we think in cross-examination, we think asking more number of questions is the good, spending more time for questions is good. But
my message is, least amount of questions should be asked, and don't ask questions if you have to, unless you have to. If you don't have to, just leave the case.
So if I come to the third question that I have now, you are today a very successful professional in the bar and very famous, partly because you were lecturing to the law students for so many decades, and most importantly, you have written over 40 books on different areas of law. And you as President Counsel today, spending a busy life in the private bar. What are the secrets of your success? I know it may be unique to you, but we would like to know how you became a very successful person in this very competitive profession.
It's like this. From my small days, I have this habit of getting up at 4 o'clock in the morning. That is something which was put into us by our parents. And
almost every day?
Every day, not almost every day. Even if I come home at 2:30 in the morning, I'll get up at 4. right? In the day, I might sleep for a few hours to compensate for the loss that I had. But 4 o'clock I get up and I write for about 2 hours. Now writing, I must say, why I was motivated for writing. When I was an apprentice, I got married in 1987. And I did not want to burden my parents with the money. So I wrote 2 books. Those 2 books are not available anywhere. They are out of print.
What are the books, sir?
Section 66 Digest and a digest on the Forest Ordinance. Even I don't have copies. And I printed. I did not have money to print at that time, so I wrote them. 1,000 books each. Each book was sold for 35 rupees. And basically the 2,000 books went within 2 weeks. No one was writing at that time. So then a few friends of mine told me, you have done 2 digests, why don't you start writing a proper book? So gradually I was parallelly lecturing at the law college. So I thought lecturing is going to be benefited if I write a book, because that knowledge, you will be brushing your knowledge and it will facilitate both ways. Lecturing is beneficial to writing, writing is beneficial to lecturing. So because of that, I started writing. And also I found what I write is not big books. I am doing a few big books, which will be the final set of books that I will put out on criminal law, civil law and evidence. But at the same time, these are small tips for young lawyers who, because I find today's young lawyers are extremely intelligent when it comes to the internet, the technology and technology-based situations. But they lack reading habit. Reading, when I say proper reading, is not reading the internet. Reading a book in book form. That is, even today, if I want to refer an authority, I would always refer in the book form. I will not go to the internet and download, because I find I have come across situations where the references are wrong. Yeah. Sometimes on the downloaded material.
Online materials.
Okay, as for a person of my vintage, I am 51 years old now, of my vintage, I would say that I am technologically more advanced than most of my contemporaries. Because I made an effort to learn about the computers and advancement of technology. But I would still prefer to go back to a book and do my reading. So what I do is 2 hours in the morning I write. At this moment, I am writing together, collectively 4 books. Right? I am trying to finish them by the end of the month. So, writing, why I write is, I want this field to be an equal playing field. Right? If reading material is provided to young lawyers, if they have the ability to go through that, if they have the time to go through that, they will have an opportunity of bringing up your knowledge. That is why I have written on several topics, several subjects which are important for practitioners. That is my main focus and main target, is to facilitate the people who are at the bar. There is one problem, because now during my time, when we had very few books, local books, local texts, I still recall with a lot of gratitude the books written by Professor G.L. Perez. Right? Professor Perez's books were the only books which were available to us. His offences under the Penal Code, General Principles of Criminal Liability, then Law related to Evidence, Property. Those books were the texts that we used. Now what happened was, the academics in the university stopped writing from that point onwards. No one has written, you can write a book and publish it, but if it is not of any value to the practice and the profession, I won't call it a useful book. Now Professor Perez, we still use that. I believe even you would have come across.
Of course.
Right? As a first year law student, those were the very first set of books that I bought, which I still recall with gratitude. And what happens is, thereafter, after Professor Perez's period, then there was Professor Nadraja, H.W. Thambaya. Those academics, they wrote books which were useful to the profession. But thereafter, books of that nature were not coming out from the universities or from the academics. My first advice to young lawyers is, respect the traditions of the bar. We have a lot of unwritten traditions which have inherited from the British principles. Respect them. Respect the values values of humanity, not only of the profession. Then there is a very dangerous trend in Halstoff and other areas which are developing, that sometimes juniors of a particular chamber, they respect only their senior, not the others. They don't offer a seat to any other senior. That is wrong. Seniors are seniors, and juniors must all look up to their seniors as seniors. They are entitled to be respected. Then fourthly, don't waste time when you are young. Just do some reading. I see a lot of people wasting time in the canteen, in the lounge, talking about politics. Politics is important. You have to exchange your views. But my advice is spend time on reading on the law. Spend time discussing legal issues. This is the first 3 years how you develop. If you mold yourself to that discipline, later on in the years, you will find that is a very useful exercise. Then there is also, I find that there is competition which is very unhealthy competition. I have heard opposing counsel being criticized by one set of counsel, judges being criticized. You must never do that. Right? As a lawyer, we owe 3 duties. Number 1, to the client. Whatever client tells you is confidential. You can't discuss that. You respect him. Respect every brief, irrespective of the fee that we receive. Then second duty is towards the court. Never mislead court. Always make submissions very clearly, respect court. You may have a problem with the judge, but you are respecting the institution called judiciary. You must never do anything or say anything or conduct yourself in a manner which will bring down and diminish the value of the legal profession and which will cause an impact on the respect of the judiciary. You must never do that. That is where you develop courtcraft. Even if you want to disagree with the judge, you can say that in a very nice way. A very nice way. You can use the language to that effect. But never to be abrasive, abrupt, or to be blunt. You must never do that. Your third duty is towards the profession, other members of the profession. You must respect them. You must never try to talk if the other counsel is making submissions. You must never make personal remarks. Those are little things that we have learned. We have also made those mistakes when we were young, so I don't see any difference. But the only thing is we learned from those mistakes. Our seniors corrected us. And one of the biggest problems that the legal profession is facing today is that there are very few chambers available for young people to work. Yes. Values and traditions you learn from chambers, not by working at a bank or a private sector company or let alone even a firm. You don't. Chambers is the center. Chambers is the place where you learn your values from, where you learn your traditions, where you learn to respect other seniors. Then unwritten traditions of the bar, you learn it from a chamber. But the chambers are basically closed. Either no room or they don't take. So that is why I say young lawyers of today should make every effort without wasting their period of apprenticeship or the pupillage as we call it. You must make maximum effort to take the maximum benefit of by working in a chamber of a senior counsel. That is where you learn the law. You will probably invariably over the years develop the same habits of your senior. I have seen that happening. Some people even stand in court like that. Right? So, but that is where you learn. So that is very important. I am not a person who says that juniors are to be blamed. Equally, the seniors also have a duty. Seniors have a duty to welcome the juniors into their chambers, and you can't be complaining from outside. You have to do something to rectify the problems. You have to make an effort to welcome people. Today the profession has opened out. It is no longer a profession which has earlier been limited to a class. So you come from different people, different directions, different locations, different geographical locations, different backgrounds, different family backgrounds. So once they come, there is no point in criticizing a person for his birth, or what his parents are, or for the school that he went. No. Take them, rope them in, train them, because one day he will be grateful and you will be proud. That is my message to the seniors and the juniors both. And the juniors especially, there are 3 important D's that I have always followed in my life. Determination, discipline, dedication. If you have those 3 D's, which I learned, it's not my invention, it is what I learned from my seniors. If you are determined, if you are dedicated to a cause, and if you are disciplined in every sense, sky is the limit. And you have so many opportunities in this profession.
Thank you, sir. Thank you very much for sharing us valuable thoughts of you with your busy life. And I wish you all the best for the books that you are now been writing. And I also want to make a request that most of the books you have written so far either not available, sold out. So I humbly request you to reprint.
Yeah, we are going for the reprint. We are going for reprint.
Because we find even from outside Colombo, lawyers reading your books, and I see when they come to court reading your books. Because I mentioned, as you said, in addition to lecturing, what you have done by writing books are very much important because it will be there forever for us to read.
I hope so, and I hope all the juniors will also start. I mean, writing is not. I was not born as a writer. I understand what the requirement is. It doesn't take a lot of, it's not rocket science to understand what the requirement is. You put yourself down. And I hope articles would come from the younger generation of people. Because the legal literature in Sri Lanka is not enough. Even today I would say, there must be more and more literature coming out so that everyone will have an equal playing field.
People can use it.
Yes.
So thank you very much for your time, sir.
Thank
you all the best.
Thank you.